I'm Gregorie Bisson. I'm the head of the International Designs Registry at the World Intellectual Property Organization. The World Intellectual Property Organization is an organization that is part of the United Nations system. It is specialized in intellectual property matters, and its mission is to make sure that member states are providing and are equipped with appropriate IP framework and infrastructure and legislation.
I heard from you, you're speaking in 2012, we start, like how to say, do something actively involving your organizations, 2012, right?
Absolutely.
Yeah.
It's
What kind of meaning is it there?
It's part of Wipo's mandate to administer a number of treaties that make it easier for the industry to get intellectual property protection amongst the member states. And one of these treaties is the Hague System, and Korea has announced it would become party by July 2012 to the Hague System. Therefore, the benefits for the Korean industry would be an easier access to design protection in the other members of the Hague System, and that includes a growing number of interesting markets. We have now up to 61 contracting territories covered, including the whole territory of the EU and Singapore, and non-European countries that are neighboring to the European market, such as Switzerland, Turkey, Ukraine, and some states from the Arab region. So it is quite, it's opening, we would be opening a highway to protection for Korean industry. And of course, as we know, Korean design is getting more and more in the forefront of of international scene. So it's quite important that Korean industry be able to easily get protection for its innovative design if it doesn't want to be copied abroad.
As I understand, like not for like Korean industry, but single designer can apply for Hague system. Is it possible?
Yes, absolutely. When I mean industry, I mean in general those involved in design innovation. But it doesn't have to be a large corporation. It can be a small and business enterprise. It can be an individual designer. The fact that Korea would join would give access to any individual Korean designer to cheap, affordable design protection in the whole of the Hague system.
So you giving information about Hague system. What do you want to say to Korean people, like Korean industry or Korean designers? And do you have some mind or thinking?
Definitely, the first thing I want to say is that we need to congratulate the government, the Korean government, and KIPO in particular, for looking seriously into acceding to the Geneva Act of the Hague Agreement. It is important that Korean designers and Korean corporations be given accessible protection for their industrial designs. I know it's quite a challenge for KIPO to implement accession to the Geneva Act as part of its industrial design framework, but it seems to be really dedicated in making sure that this will be a success, because it fully realizes that it is something that is essential to the economy of this country and to the benefits of the design profession in Korea and the industry, the Korean industry at large. So again, I want to congratulate KIPO on its intensive efforts, and I want to reassure KIPO and the industry also in Korea in general that we're very much at Wipo, we're very much in their hands into helping them as much as we can, making sure that this would be a smooth and successful process.
Good morning, everybody. Is this microphone on? Yes? Thank you. You shy people, you tend to sit at that corner of the room and leave that entirely free. I feel I need to do something to break the ice so that we all feel more comfortable this morning. Why don't I suggest that we do something to create some bonds? I suggest that, for example, everybody has a watch. Yeah? Show me your watch. Come on, don't be shy. Raise your hands, show me your watch. Yes, come on. Very good. So I suggest the following. I take off my watch. I'm going to ask Miss Yoon to give me a hand here. She's going to bring a bag. I'm going to drop my watch into that bag. Then Miss Yoon will walk around the room, and each of you will drop his watch or her watch into the bag. With full room. Everybody does it, please. Then Miss Yoon comes back again, does another round, and everyone picks up a watch from the bag. No peeking in the bag, okay? You pick up a watch, keep your eyes closed, and as Miss Yoon comes to you, you take a watch. And we will each walk out of this room with a token of friendship, a trade that will remind us this seminar. So are you game? Shall we do it? Ah. I see some people nodding, yes, but I see other people going, no, no, no. Why don't you want to play this game, those who say no, no, no? You think this is not a good watch? It's a fairly accurate watch. There's no watch that is not accurate in the 21st century. All the watches are reliable and accurate. So why don't you want to do it? Well, I'll tell you why. You don't want to do it because your fear is that you would pick up a watch that you don't like. And why wouldn't you like it? It's because its design will not suit your taste. And that shows precisely the value of design in today's society. Technology is becoming more and more open. There's not a bad car on the market today, just like there's not a bad watch on the market today. But the consumer choice is driven by the design. Of course, also the trademark, but the more prestigious the trademark is, the more expensive the watch is likely to be. And not everybody is willing to spend a lot of money on a watch. So leaving aside the value of the trademark, at equal price, what drives the consumer's choice is the design. So this example is a preamble to remind us of the value of design in today's society. More and more companies are relying on design with a view to keep or increase their market shares. What you see on the screen now is the topics we'll be addressing. So I'll just touch briefly the preamble. I will go back to this in a moment. I will give you a background about the Geneva Act of the Hague Agreement. Then we'll step into the basic features. And then, in a nutshell, I will try to recap everything by stressing the advantages of the system for users, for the IP profession, and for the office. I have to apologize. Kipo has been kind enough to print out the presentation. It's part of the booklet that has been circulated to you. But yesterday evening, I thought I could bring some improvements to my presentation. So what you will see in the screen is maybe different at times from what you have in the written material. And I apologize for this also to our colleagues interpreters. And in addition, not all the slides that you have in the written material I will show on the screen, this in the interest of time. But let us go back to the preamble. So we all agree that industrial design is critical to the industry because it is something that prompts consumers to buy products. But the bad news about industrial design is that you need to protect it if you don't want people to copy it, and getting international protection, worldwide protection for designs is cumbersome. Why is it cumbersome? It is cumbersome because industrial design rights are territorial, which means that on each jurisdiction where you want to have protection, you need to apply for protection. Well, this is where the Hague Agreement brings a solution. I'm Canadian, so let me give you the example of filings made abroad by Canadian enterprises from my home country. What you see in blue on the map is the European Union. I'm sure most of you know that across the European Union, they have a single design regime for industrial designs. They call it the RCD, for Registered Community Design. It is a registration facility that allows people to have a single title for their designs for the whole of the European Union, which again you see in blue on the screen. Last year, Canadian enterprises filed for 530 RCD applications. That means design applications for the whole of the European Union. That is quite a big number, and it shows how important design registration is to Canadian enterprises in that market. Bizarrely, however, there has been only 3 design applications filed in Switzerland, which is the patch of orange that you see exactly in the middle of the EU. Only 3 design applications filed by Canadian companies in 2010. There's been only 1 in Turkey, which is the patch of orange that you see at the bottom right corner. Turkey, which is a very important country for whoever is interested in the European market. Only 2 in Norway, which is the patch of orange that you see at the top. Norway is a European country in the geographical sense, but it's not part of the European Union. So that means that when you're applying for RCD, you're getting protection in the blue part of the map, but you're not getting protection in Norway, because Norway is outside the EU. So I ask you the question, why did Canadian companies did not file? Don't be shy, there are some very good seats at the front here. Why did Canadian companies didn't file for design applications in neighboring countries, countries just part of the geographical Europe but outside the political Europe? Is it because they have no interest in these markets? I don't think so. Logically, someone who's interested in protection in the whole of the EU would also be interested in protection in the neighboring markets. Or is it because access to protection is too cumbersome? Well, I think it's the latter. I think it's because they reckoned that it was too cumbersome to get design protection in these neighboring markets. Too cumbersome because once they had filed for the RCD, then they needed to make another application for Switzerland, and another application for Norway, and another application for Turkey, every time in different languages, submitting themselves to different procedures. And they would end up with different registrations, different titles that they would have to manage. So they simply, because Canada is not a party to the Hague Agreement, they simply decided to forego protection in these countries. Well, the Hague system is there to provide, again, a solution to this. The Hague system is for the centralized acquisition and maintenance of industrial design rights by filing a single international application for a single international registration with effect in 1 or more designated parties. So that is a very technical statement, but I can illustrate it in this way. What you see on the screen is what we call the national route. Again, if you want to have design rights in countries A, B, and C, outside the Hague system, you need to file independent applications with offices A, B, and C. And that can be cumbersome. The Hague system, which you see now on the right-hand side of the screen, allows you to find a single application with the International Bureau of Wipo in Geneva, submitting yourself to a single procedure, and you would be getting registration rights or industrial design rights in countries A, B, and C. So now, if you go back to our map, what you see now, the figures that you see now, the percentages that show on the map, give you the percentage of applications filed under the Hague system that seek effects in these contracting parties, because all the countries and the EU that you see on the map are parties to the Hague system. Now what do we see? We see that 70% of Hague applicants last year asked for protection in the EU, and the exact same proportion of applicants, that means 70%, also asked for protection in Switzerland. So I think that is quite a striking contrast with this slide here, where you see that you had 530 Canadian applicants or designs filed by Canadians in the EU last year, and only 3 filed by Canadian applicants in Switzerland. You see the disbalance, the very strong disbalance. Under the Hague system, exactly the same proportion. So every time someone would file for the EU, you would say there would be someone filing for Switzerland, which precisely shows the advantage that the system offers. It gives you a facilitated access to protection in these countries, which means again that every time you want to have protection, every time you have an interest in the EU, you don't have to hesitate about asking protection in the neighboring countries, because access is facilitated. So enough for the preamble. Let me now give you some background facts and figures about the Hague system. And let me turn for a very short moment to our colleagues interpreter to make sure that they're doing okay in the booth. Is the speed okay? Yes? Okay, thank you. The Hague system is not a recent system. It dates back from 1925. And there are currently 3 acts in force: the 1934 Act, the 1960 Act, and the latest Act, which is the 1999 Act. I'm going to focus solely on the 1999 Act. Why? Because this latest Act was adopted precisely to introduce flexibility to accommodate novelty examination systems. I'm not going to walk you through this list, but this is the list that contracting parties joining the Geneva Act, and the list of declarations that contracting parties joining the Geneva Act can make with a view to have the system operate more smoothly in conjunction with the national law. The Geneva Act is completed by common regulations. There's also a set of administrative instructions, so that's the third level of legislation that applies. And finally, an essential part of the system is national law. We will see why later on. What you see in this chart here is the number of contracting parties to the system through the years, according to the latest act to which they are party. Contracting parties bound only by the 1934 Act are shown in yellow. Those that are bound only to the 1960 Act are shown in red, and those that have joined the Geneva Act are shown in blue. So you see that the Geneva Act, which was adopted in 1999 and which came into force in 2003, you can see that it very quickly grew. In fact, more and more contracting parties bound by the older acts have upgraded their status by joining the Geneva Act. And a great number of contracting parties that had so far remained outside the Hague system have joined also the Geneva Act. With the consequence that what you see in blue today on the map is the membership of the Hague system according to the Geneva Act. So these are all the territories covered by the Geneva Act. There are 41 members, that means 41 contracting parties to the Geneva Act, but in fact, because 2 of these contracting parties are intergovernmental organizations, precisely the European Union and the French African Intellectual Property Organization, which altogether comprises 27 states and 16 states. Well, this makes it so that, in fact, there are 68 states covered by the Geneva Act today. So 68 jurisdictions that you can target with a single application. Still, we would like to see a lot more blue on that map, but be patient. This is coming. This is coming. We know that in the USA there is implementing legislation pending. The legislative, this implementing legislation just needs to be introduced in Congress. All it needs is an industry push. I was in the USA just 3 weeks ago in Washington, and we are definitely getting that push by the industry organized. So stay tuned, the US shall be joining soon. We know also that China is actively studying the Geneva Act. And of course, we were very happy to hear last year that Korea had decided to join the Geneva Act. And this is going to be a major development in the system. I'm sure accession by Korea by July 2012 is going to act as a catalyst for the rest of the world that so far has been slow in considering joining. Still, let us go back at the figures at present. There is already a critical mass of countries that justify using the system, and in fact the figures show this. Just last year, there's been almost over 11,000 designs filed under the Hague system. That was a 33% or 27% increase over the previous year. And I think that's a very good result given the gloomy economic times that we're going through. And this year, the forecast for this year is an equal growth of between 25% and 30%. So the system is getting more and more used by the industry. And the last line that you see on the screen is a bit of a provocative statement. You know that the USA are not party to the system, yet last year 8% of the filings were made by US companies. I will tell you why and how this could have happened in a moment. Just keep that in the back of your mind. Now I'm going to take you slowly and slowly more and more into the procedure. The Hague system, what it is and what it is not. The Hague system is a procedural agreement for the centralized acquisition and maintenance of rights. I'm sure many of you are familiar with the Madrid system to which Korea is a party. The Hague system is very much the same as the Madrid system. Because it is a procedural agreement and not a substantive law treaty, the Hague system does not determine the conditions for protection. It does not determine the procedure to be applied where there are objections to protection. And it does not regulate the rights which result from protection. All these issues remain the sovereignty of the national law of each governing party. And this is why I said earlier on that national law is an essential part of the system. So it's only a procedural treaty, not a substantive law treaty. Who can use the system? Well, again, the parallel with the Madrid system is evident. The Hague system is a closed system. In order to use the system, you have to have a connection with a contracting party. And that connection, you can have it through nationality, domicile, through residence, or through the fact that you possess what is called a real and effective commercial or industrial establishment on the territory of a contracting party. This last notion of real and effective commercial or industrial establishment is a notion that comes from the Paris Convention. And it is because this is a possible criteria that allows somebody to use the system, that last year 8% of the filings came from the US industry. Because some large US corporations reckoned that they possessed such an establishment on the territory of a counterparty, usually Switzerland or the EU, and they used the fact that they possess such an establishment to file under the Hague system. How do you file an international application? It's very easy. First, you file in English, French, or Spanish. These are the 3 working languages under the system. You file directly with Wipo. And for those of you who are familiar with the Madrid system, let me stress this. It's a very different, very important difference with the Madrid system. Under the Hague system, you don't need a basic application. You don't need to file through your office. You file directly with the International Bureau of Wipo. You can file on paper, but you can, of course, also file electronically. On our website, you have a page for forms, and you also have a link, which is circled in red here, a link to our e-filing interface. In fact, now 80% of our filings are made electronically. So direct filing with Wipo using the e-filing interface. This will surprise you. You can file up to 100 different designs in a single application. The only condition is that they belong to the same class of the low kernel classification. The low kernel classification established under the low kernel agreement that Korea just joined. So 100 different washes can be filed together. All the washes in this room can be filed together in a single application. Or it can be these chairs and these tables and this stand here, because these are different pieces of furniture, but they all belong to class 6 of the low kernel classification. So an applicant would file all of them in the international application. You pay only one set of fees. That means that you don't have to pay fees with each offices where you're seeking protection. You pay only one single set of fees in one currency. You pay the fees directly with us at Wipo, and we deal with reverting the money to the designated offices. You don't need to appoint a representative before Wipo. You can certainly do so if you so wish, but you don't have to. And of course, you will be using local representatives every time you will need to defend against refusals. But then it would be local representatives that you would appoint in each designated party. What do you have to put in your international application? There are some, of course, compulsory elements, and if you don't provide them, you won't be getting the filing date. These are, of course, the identity of the applicant, the identification also of your entitlement, so what gives you the right to use this Hague system. You should at least designate one contracting party. And of course, you should enclose the reproductions of your designs. And I will be saying a lot more about reproductions in a few minutes. There are also certain elements that you will have necessarily to include when you designate certain contracting parties. I'm not going to step too much into legalese at this stage, but certain contracting parties would require that when you designate them, you include in your application a description or a claim, or you provide the identity of the creator. And if you don't put these elements, then your filing date will be affected. Let me focus on the procedure. What does the International Bureau do with your international application filed electronically? We conduct a formal examination. If successful, then we will record in the International Register your designs, and we will issue you a certificate. So you will be getting a single title, which is the International Registration Certificate. Then we will proceed to publication in the International Designs Bulletin, and that publication will serve as a notification to the offices of the designated contracting parties. So this is what will tell them these designs ought to be protected in your territories. And if you don't want to protect them, you have to give the reasons why. And from that moment on, the effects of the international registrations are the same effects as the regularly filed national application in the designated, in the territory of each designated contracting party. So I'm going to walk you through each of these points very carefully. So the first stage, again, is the examination by the International Bureau. So what do? Well, we have an easy job at Wipo. We don't get into substance at all. We simply check that the international application complies with the prescribed formal requirements. In particular, we do not check for the definition of a design. In fact, the Hague Agreement does not contain the definition of what a design is. We don't check designs against public order, and we certainly do not carry out any novelty examination. We don't do that. We simply look at compliance with the formal requirements. That means that we make sure that the application is complete and in order, so we make sure that all the compulsory requirements or elements are there and correctly indicated and presented. We also make sure that optional elements, like a priority claim, are correctly indicated. And we make sure also that unauthorized elements are excluded. Let me focus a little bit on one of the critical elements that have to be provided, which are, of course, the reproductions. This is a highly regulated part of the Hague legal framework. Let me first say that there's no requirements as to the number or type of views that an applicant can submit an application. If you want to show your design in only one view, it's up to you under the Hague system as far as the International Bureau is concerned. If you want to show your design according to 10 different views or 15 different views, again, it's up to you as far as the International Bureau is concerned. But we do have certain requirements, and they concern not only the contents, in the sense that we want to show, to see the designs to the exclusion of any other matter. So for example, if the application is for the design of this stand here, then you don't want to see the speaker on the photograph, and you don't want to see the microphone. We also have requirements regarding quality, which we enforce very, very rigorously. Why? Because we know that certain offices are performing novelty examinations. And it is the quality of the reproductions that will lead to a registration that will then serve as a basis for the substantive examination work that is performed by certain designated offices. So we make it sure that what we get from the applicant is of an excellent quality, so that the substantive examination officers can do their part of the work. So these are examples of reproductions that we accept. You see that we accept black and white photograph, color photographs, black and white line drawings, or color drawings, or of course computer aided drawings, CADs. If the application is not in order, we will send the applicant an irregularity letter, and the applicant will get 3 months to correct the deficiency. And in most instances, the filing date will not be affected. There are some also, like I indicated, certain optional elements that can be included in the international application. And again, certain of these elements may be required in a specific cases depending on the connecting parties that you designate. Let me now focus on stage 2, which is the publication. This is a critical phase in the international registration process because, again, the publication takes the place of the national publication. Offices can be published at their end if they so wish, but they don't have to. The mode of publication is publication on the web, on the internet. You find the link here. And the most important aspect of publication is that the refusal period for offices to raise objections against the designs that seek protection for their territories starts from the publication date. As to the timing of publication, there are 3 different timings. If you file the application without expressing any specific requirement as to timing of publication, your application will be published 6 months after filing. But you have another 2 options. You can ask for immediate publication, in which case we will publish as soon as possible after registration. Or you can ask for deferment of publication. And deferment of publication, I'm sorry, going too fast here. Deferment of publication can be asked for up to 30 months. So you can delay the publication for up to 30 months. Of course, a number of statutory conditions apply. It depends notably on the designations you've made in your application. There are certain contracting parties that when you designate them, they would prevent you from asking deferment. But normally you can ask for deferment for up to 30 months. So after publication, again, because I said that publication in the International Bureau, in the International Bulletin serves as a notification to the offices of designated parties. After publication, then the office role kicks in. So what is the role of the office of a designated party? Let me first stress that the Hague system itself does not impose any specific role on officers of connected parties. There's no specific Hague task that an office has to perform. And again, for offices, this is a major difference with the Madrid system. The Madrid system imposes a specific role to the office of each member state. That role is the role as the office of origin. A number of things have to be performed by the office of origin, notably the certification that the international application is for the same matter than the basic application. There's no such role under the Hague system, which makes it a far easier treaty to implement at the national level. And when comes, of course, the role as a designated office, so there's no specific examination role that is imposed by the Hague system. The substantive examination that an office will subject international registrations to will be exactly the same examination that it applies to national applications. So if the national law provides that there will be some kind of substantive examination that the office has to do in respect of nationally filed application, then the office will do exactly the same kind of examination for international registrations. And this may lead to the office willing to refuse protection. Well, of course, it is perfectly entitled to under the Hague system. It is entitled to under the refusal mechanism. So let us see this in details. The refusal mechanism first is subject to a timeline. The refusal period starts from the date of publication. The refusal does not need to be a final decision. It can be just a preliminary objection from the office. But it's just a signal that the office is not willing to spread protection as things stand. That refusal has to be expressed in English, French, or Spanish at the election of the office. The refusal may be total or partial. Partial in the sense that you would remember that you can have up to 100 designs filed together, so only maybe some of the designs that are filed together have to be refused. Let me reassure you, we never see an application that contains 100 designs. The average number of designs filed together is between 4 and 5. That means that a great number of design applications are single design applications, and we see also a number that contain more, up to 10 or 15. But the average is between 4 and 5. And then, let me go back to the refusal procedure, and then when an objection is raised by the office and communicated by means of a notification of refusal, the remedies that the international holder enjoy are exactly the same remedies as you would normally enjoy under national law. So that means the right to reply to the office, the right to appeal from the decision. Again, this is an area where national law is sovereign. Time frame, I did say a moment ago that the publication was the starting point of the refusal period. The time frame usually is 6 months. For offices which are examining offices, and that means offices that carry out novelty examination with a view to making sure that the designs filed meet the requirement of novelty as laid out under the national law, well, these offices can enjoy up to 12 months. What may be the grounds? This is very important. An office may not issue a refusal on the basis of formal grounds. For example, we would like the description to be redrafted, or we would like the black line drawings to be replaced by photographs. These formal objections cannot be formulated under the Geneva Act, because it is the International Bureau that is entrusted with formality examination. So refusals can only be expressed on the basis of substantive grounds. There are 2 exceptions which are very important. A contracting party, when joining, may make the declaration that whenever it is designated, it wishes to receive specific views. That means that every time an application is made for a 3-dimensional article, there has to be, for example, a front view, a back view, a side view, etc. So if the office makes that declaration at the time of, the contracting party makes that declaration at the time of joining, an applicant who does not comply with this requirement in filing will be receiving a refusal. And the other very important exception is requirement as to unity of design. Again, a contracting party joining the system may make the declaration that when it is designated, the international registration that contains more than one design would have to be split. Hopefully, following a notification of refusal, the international holder, which was provided the same remedies as any national applicant, would be able to overcome the objection. Then the office would have to issue a withdrawal of refusal, and the International Bureau will record this withdrawal in the International Register. The withdrawal may be partial also, and of course the office could issue what is called a statement of grant protection. And in fact, we do encourage officers to issue statements of grant protection. Then what are the effects if there's been no refusal or the refusal has been withdrawn? Well, the effects of an international registration, again, after publication, it's the same effect as a national application. And if there was no refusal or the refusal was withdrawn, the effects are the same effect as a registration at the latest from the expiry date of the applicable refusal period. Or in case of a withdrawal, at the latest from the date on which the refusal was withdrawn. There are two minor exceptions to this principle, but I will not bore you with these details. You have the slides in the material that was distributed to you. Let us recap on the situation in a designated contracting party. Again, the office of a designated contracting party will have to carry out the same kind of substantive examination that the law provides, and will be able to issue refusal on the same substantive grounds as for national filings. These refusals would have to be communicated in a specific time limit. And of course, the effect of a refusal is limited to the territory of that contracting party. It's not because one office of a designated contracting issues a refusal that it affects the whole of the registration. The effects of a refusal are limited to the territory of the office that issued the refusal. And in case there are no refusal, then the same rights, the holder enjoys the same rights as under a local design registration. So that means that you are getting, and this is where we're getting into the crucial part of the system. That means as a holder, you are getting a bundle of national or regional rights under a single title. And this is really where the beauty of the system lies, because it allows you to centrally manage your protection for all these territories. I will get back to this. Let me just remind you also that, of course, there can be an invalidation by a court in any designated contracting party, in which case the office would have to communicate that decision and invalidation. But if there's no invalidation, the situation is that you have a title that is renewable every 5 years for each contracting party concerned. And then again, that gives you the advantage of central management. And here it's more or less the same advantages as for filing. Central management means that you have only one application for renewal or change in ownership, for example, to file with the International Bureau. So we'll get more into detail about this. This is what we saw a moment ago, the advantages at the time of filing, the advantage of going through the international procedure as opposed to national filings. Well, it's exactly the same throughout the life of your title. The Hague system is providing you more than just a filing route. If you need to file a renewal or a change that would affect your rights in countries A, B, and C, you don't have to file this with each office of countries A, B, and C. You file this through a single request with the International Bureau of Wipo. So again, you save a lot in terms of time, money, headaches. Single application filed through Wipo, we will process it, and we will record the change and notify it to the offices of each contracting party. And this doesn't mean that there's no flexibility. On the contrary, there is flexibility. If the recording of the change in ownership, for example, is only for countries A and B, A and C as on the slide, or if you assign your design rights for only these two territories, but you keep your design rights for country B, you can do so under the Hague system. You can split your title as you want. Same for the renewal. You can be selective to the territories where you want to renew and where you want to drop your design rights. And you will remember that because the registration can contain up to 100 designs, you can be equally flexible in terms of designs. If you want to assign only designs 1 and 3 for countries A and C only, you can do so, and you keep design 2 in country B for yourself, for example, and you keep, of course, design 1 and 3 for in country B for yourself also. So you have this entire flexibility under the system. So the general advantages of the X system from a user's point of view are not only at the time of filing, but throughout the life of the registration, of the design rights. Advantages of single management, which saves you a lot of money, a lot of time, lots of headaches. So I hope that by this time you're convinced, and I'm bringing this presentation to a close now, you're convinced that it is a cost-effective and efficient system, thereby it creates opportunities that would not otherwise exist for any enterprise with a limited IP budget. And also it is a flexible tool, so it affords right holders great flexibility in targeting national, regional, or global markets for particular goods. There are, of course, advantages for an office of a party. The advantage is that the normal work is reduced. Hague system allows national offices to reduce their workload because they're relieved from formal examination. Everyone knows that some applicants make formal mistakes when they file with an office. Well, the office gets a clean file under the Hague system from which it can base its substantive examination. And then the office can focus. The office can focus on added value tasks like guidance, counseling, or novelty search. These are added value tasks. But the office is relieved from the chore of dealing with messy applications. We do that for offices. And of course the office keeps its whole sovereignty on substantive issues. There's also some advantages for the IP profession. There is opportunities for the IP profession. Let me stress this. We all agree that industrial designs are the Cinderella of intellectual property. What I mean by this is that they're often overlooked. There's a lot of business for patent application, trademark application, but we don't see a lot of design applications. There could be a lot more, especially given the importance of design in today's society. I think there's a very big market untapped here. And again, why is it untapped? It's mostly because industry feels that if it needs to go through local applications, it's not worth it. Designs are limited in time, more than patents, and definitely more than trademarks for that matter. And they tend to forego. But if you give them a highway to protection, a cost-effective and flexible and efficient highway to protection that is the Hague system, then they're more likely to consider industrial design protection as part of their strategies. So there will be new opportunities for the profession, a new business line for the protection, for the profession. There will be more filings for more territories. And that would mean more opportunities for the IP profession to consult their clients. There will be also more contract or licensing related work for the IP profession, because there will be more business based on industrial design protection. And there will be also other opportunities relating to enforcement or settlement issues or opposition issues. But of course, this will only happen if you do consider the Hague system, if you're willing to consider the Hague system. You know the saying, it's the early birds that catch the worms. So I would really encourage you, if you want to seize that opportunity, to be the first to start considering the Hague system and studying it. And I think that your presence this very morning and your patience in listening to me really shows the fact that you are willing, in fact, to be part of the early birds. That brings our presentation to a close. I would be very happy to answer any questions you have whenever the Q&A period is with us. Thank you very much for your attention.